right? Don't make me regret it. Do the right thing. You hear me?
You won't.
Attorney for the people.
Brian Bowling on behalf of Mr. Smith, Your Honor.
Right away, that opening line sets the tone. Don't make me regret it. That's judge code for you're getting a chance. Don't waste it. Whenever a hearing starts with that kind of warning, you already know this defendant is on thin ice. The real question is, has he learned anything, or is this about to unravel fast?
State your name for the record, please.
Marshan Smith.
Thank you. Judge, we're asking this matter be set for a preliminary examination.
Discovery is complete.
I believe it is, yes.
People, other witnesses available the 13th.
Yes, Your Honor.
Preliminary examination in person, January 13th, 2026, 9 a.m. before me. Bond will continue.
Your Honor, may I address bonds?
You may.
Your Honor, this is the only matter holding Mr. Smith, to my knowledge. There's a $25,000 bond. He indicates to me that he is employed at Toyota in Saline, which is a very good job. He believes he will lose that job if he remains in custody any longer. Further, it's come to his knowledge that
Here's where things get serious. A $25,000 bond isn't small, especially if this is the only case holding him. Defense is about to argue hardship, job loss, eviction, family impact, and judges do weigh that. But remember, bond isn't about convenience. It's about public safety and whether the defendant will follow court orders. So which side wins here?
apartment that his fiance and daughter live in Ypsilanti, that they are going to be evicted from that residence if he's not able to be the financial support for those individuals, which ultimately ties to my early argument regarding his job. He indicates to me
the
that
apartment in his name.
It is.
yes,
Who's the landlord?
We just moved there. We moved out of Arbor One into this apartment.
what's the name of the apartment complex?
I can't
So
remember.
you just moved out of Arbor One. How long ago?
Like 60 days. We moved out of Arbor One into this apartment. We've been trying
Because you were trying.
Because it was
the mess
condemned.
over there.
Yeah, it was condemned. And we just got this apartment, Your Honor. I don't want to lose it.
Gonna just
Okay, have they started? It's in your name?
Wait, condemn housing? That changes the emotional temperature of the room. Now, this isn't just about bond money. It's about stability, homelessness, and a family possibly being displaced again. Judges are human. When housing insecurity enters a conversation, it can absolutely influence bond decisions.
The apartment is in me and her name, yes.
We don't have any in his name.
I could try to come up with the lease or something, but if my name is on the lease with her.
You know, when you're winning, you should stop talking.
Sorry.
See, the way he reacted, thank you, sir. If attorneys would react that way, my day would be so much easier. Anything from the people.
Yes, Your Honor. Your Honor, the facts of this case, Mr. Smith was released on a DV case. It's a city prosecution out of Ypsilanti. Several hours thereafter, the police were called because he had contacted the victim's grandmother. The victim's grandmother called the police, indicated that he had told her that he was on his way over and did not care what happened. There was a no contact and a stay away order in place on the domestic violence bond. When he arrived, police had already gotten there. He was observed by the arresting officer standing outside. The officer asked him to stop and come and speak to him. He immediately ran. The officer had to chase him out of the building, down the street, through the snow, until eventually he fell down. The officer tased him. He did not stop. Eventually, he was able to take him into custody. The people are very concerned about his refusal to follow the court's orders regarding bond, as well as his refusal to follow the orders of law enforcement.
may I respond to that? Your Honor, it's my
And this is the prosecution's hammer. Running from police, violating a no-contact order, getting tossed and still not complying. From a legal standpoint, that screams flight risk and noncompliance. If bond is about whether someone follows rules, this narrative hurts. Badly. So now the judge has two competing stories. Struggling family man or someone who ignores court orders.
Understanding that Mr. Smith, regardless of any other calls that may have been made, was he reached out to the Ypsilanti Police Department for a civil standby or civil assist visit at that residence to obtain some items. It's my understanding he was in communication with the Ypsilanti Police Department, actually received a return call from them telling him to go to that location. I mean, ultimately, we're here for the allegations that Mr. Overwater just stated happened once he came in contact with the police at that location. But
what happened to the underlying DB?
It's still pending. There is a personal bond on that case.
So
I believe it was scheduled for a hearing yesterday. Nothing was changed.
So that's what I'm trying to figure out. So if the violation is for the underlying DB, he goes there, which would be a violation on that case, and where you would suspect that his bond would be denied.
Fair enough, but
his bond is not denied. He has a PR on that case, and because all right,
and I mean, I'm not sure exactly what happened with respect to the
what did
call.
I tell your client?
Yeah, fair enough.
Okay.
This is the technical twist. On the underlying domestic violence case, he already has a personal recognizance bond, meaning he was trusted to stay out without paying. So if the court believed he was that dangerous, why wasn't bond revoked there? The judge is essentially signaling. If there's a safety issue, it needs to be handled consistently. That's sharp judicial reasoning.
I understand the circumstances, but if there's really a safety issue with this individual and not being able to follow the orders, that needs to be taken care of in that other case. I'm looking at this case. I think his bond is inappropriately set. I'm also, because of his Arbor One situation, I'm a little bit worried if he loses that apartment. He's probably sat in a condemned unit for a number of months, just trying to find a way out. So what I will do is I'm going to grant the motion for a bond reduction. His bond in this case will be reduced to $25,000 personal recognizance bond.
And there it is, bond reduced. That's a major break for the defense. The judge balanced compliance concerns against housing instability and employment risk and chose conditional trust. But notice that warning at the beginning? Don't make me regret it. That's not just a line. That's a final lifeline. So now it's on Mr. Smith. Does he walk out and straighten up? Or are we seeing him back in this courtroom soon?
Thank you. Thank you, Your Honor.
And thank you.
You're welcome, sir.
Thanks, Judge.
All right? Don't make me regret it. Do the right thing. You hear me?
You won't, Your Honor.
All right. Take care.